Hi all, happy Monday. Welcome to The Wife of Caesar. My name is Michel Bien, or Michel Bien, either's fine. Today we have a special episode in The Wife of Caesar. This is the first episode of our series of special interviews. What we will be doing is we will have special guests who are heavily related with the field of anti-corruption in different capacities, and we will interview them so that we can learn from them about what they're doing and about their plans for the future and how they plan to help the fight against corruption. On this occasion, we have as our first guest Judge Mark Wolf. He was a federal judge in the United States in one of the districts of Massachusetts, and he was most notorious for trying the case of Whitey Bulger, one of the most widely known or infamous cases of grand corruption involving the FBI. Most recently, Judge Wolf is involved in International Integrity Initiatives, an NGO that seeks to further the fight against corruption, and currently is promoting the creation of the International Anticorruption Court. The goal of this court would be to function in a way comparable or similar to the International Criminal Court. The idea is to create this independent international organ that would adjudicate cases of grand corruption in a different forum, in an independent forum than that of the person who was doing the grand corruption. To put it simply, they will try cases outside of the countries where the corrupt are not being tried because they are, well, corrupt and powerful. Okay, so we hope you enjoyed this interview with Judge Mark Wolf, and I'll leave you to it. Okay, so Judge, thank you for joining us. We're very happy to have you. We're learning a lot from you, and we would like to ask you a few questions about this project for the International Anti-Corruption Court, which is, to me, it would be a dream come true. Now, I had the privilege of studying under Mr. Samuel Buell, who was a prosecutor, and he famously prosecuted the Bulger case, with which you are, of course, familiar. And he co-authored a paper with Professor Rachel Brewster, both of Duke, where they argue, or they rather present a problem with what they call a market for anti-corruption, anti-bribery prosecution, i.e. who benefits, who gets to collect, who gets to cash in. Do you think this might pose a problem if we eventually adopt an international anti-corruption court?
I hate to start this way, but I'm not sure I understand the question.
Okay.
Are you talking about who would get assets that are recovered if there was a successful corruption prosecution?
Prosecuting corruption is profitable, and depending on who prosecutes it, different people might be paid.
Well, prosecuting corruption is not primarily done for profit. Prosecuting corruption is done to end impunity for powerful elected and appointed officials. And the primary purpose, there's a range of sanctions that get imposed. When somebody is convicted in a corruption or a fraud case, I sentence that person almost always to prison. That's intended to represent the seriousness of the crime and to deter other people, including potential corrupt office holders. I sentenced the former Speaker of the House of Representatives in Massachusetts, Sal DeMacy, to 8 years in prison. He was the third Speaker in a row to be convicted in federal court, but the first one to be sent to prison. That was in 2011. I don't know if it's cause or coincidence. No Speaker or representative has been prosecuted since DeMacy was sentenced to 8 years. So there is the power of imprisonment when corruption is proven to deter, I believe. And of course, that's a fundamental premise of the criminal law, that people will be discouraged from committing crimes if there are credible threats that they'll be punished for them. In addition, when I sentence somebody in a corruption case or almost any case, if they have the means, I order them to pay a fine. And in the United States, although very few people, including few judges, know it, the fines that we impose in federal court are used in part to finance the federal courts. So when we talk about the International Anti-Corruption Court, that's why I think it can be self-sustaining.
It'll fund itself. Right.
Then, in addition, when there are victims, we order restitution, repayment to the victims. Mm-hmm. And this, too, has important implications for the International Anti-Corruption Court. There are tremendous efforts around the world to recover illicitly gained assets through civil litigation. Mm-hmm. It's very ineffective. It takes decades. Rarely is it successful or completely successful, and it doesn't serve as a deterrent the way the threat of criminal prosecution and imprisonment would. So there are things we could learn from the civil litigation model. There's questions: do you return the money to the country? And if it goes back to the country, if there's another generation of corrupt leaders, are they just going to steal the money again? Do you give it to NGOs or put in some kind of trust? Mm-hmm. These are interesting issues, but I frankly don't think they're the primary issues.
Okay. Quick question. Do you think the court would only prosecute natural persons, or would there be room to prosecute bodies, corporations, and such?
There would be the authority to prosecute corporations, and in fact, it would be essential. And I think, not knowing how much background people watching this video will have, it may be important to briefly state the concept of the International Anticorruption Court. Mm-hmm. So, grand corruption, the abuse of public office by a nation's leader, flourishes in many countries. Mm-hmm. It has devastating consequences in terms of cost, in terms of human rights. Failed corrupt states are generating the refugee crisis. Indignation at grand corruption is destabilizing countries like Ukraine, and in the process creating grave dangers for international peace and security. Grand corruption doesn't flourish because of a lack of laws. 186 countries are members of the UN Convention Against Corruption. They all have laws making bribery and extortion, money laundering a crime. Mm-hmm. The problem is that when they're led by corrupt heads of state or government, kleptocrats, mm-hmm. Those kleptocrats have impunity because they control the police, the prosecutors, and the courts. So we advocate, Integrity Initiatives International, which I chair, advocate the creation of an international anti-corruption court, similar to but separate from the International Criminal Court, mm-hmm. to prosecute corrupt leaders of nations that don't have the will or the ability to prosecute them themselves. Mm-hmm. So that's the fundamental concept. Grand corruption involves a high-level official, but in our conception, it would also include anybody in a joint criminal venture with him or her, a co-conspirator. Right. And that would include the corporations that pay bribes, mm-hmm. As well as the officials who receive the bribes. And in fact, that's essential. I was a prosecutor of corrupt public officials in the United States. The progress of that work led to my appointment, the great honor to be a federal judge in the United States. But the only way you can, almost only way you can successfully prosecute is a public official is if you get a corporation or a private individual who's paying a bribe. Right. You threaten that person with prosecution, or you prosecute that person, and you give them the opportunity to cooperate, mm-hmm. usually through a plea bargain. And if they cooperate against and give evidence against the public official, including testimony, mm-hmm. then the prosecutor will recommend a lower sentence. Right. So for this court, it would be essentially corrupt leaders mm-hmm. and those who engage in the crimes with them.
Okay. And in our videos, we've covered MPAs, DPAs, cooperation agreements. So our public is fairly familiar with those. So yeah, great, thank you. I have a you touched on the ICC, and I have a question. I think that might be a nice segue to this question, which I don't think people like to ask you. Why not simply elevate corruption, grand corruption, to the level of a crime against humanity, and simply rely on the existing structure of the ICC to prosecute corruption?
Yeah, I think there are two parts to that question. My original paper advocating the creation of an international anti-corruption court, I wrote for the Brookings Institute in 2014. And when I wrote it, I thought I would figure out why grand corruption is a violation of human rights. And I didn't quite persuade myself of that. I think that it's closely correlated. The worst abusers of human rights are also the most corrupt leaders in the world. And the argument that I developed was, say, in the United States, we have our Declaration of Independence, which essentially is this statement of human rights, and it says all men are created equal. They're endowed by their creator with certain inalienable rights. Among these are life, liberty, and the pursuit of happiness. And governments are created with the consent of the governed to essentially protect and promote these rights. And no group of citizens has consented to bribery and extortion, looting public resources. But I didn't quite persuade myself, at least, that that was alone a violation of human rights. The related question, though, is, should grand corruption be prosecuted in the existing International Criminal Court, or should there be a statute? Well, let me put it this way. I don't believe that corruption is now within the jurisdiction of the International Criminal Court. And I don't think the judges could properly interpret the Rome statutes to include it. I think that to add corruption, to put corruption within the jurisdiction of the ICC would require reopening the Rome statutes. And in the current environment, if you try to reopen the Rome statutes, perhaps you would lose the court. And people,
altogether,
conceivably, and some supporters of the court argue that while grand corruption does have devastating consequences, it's not genocide, and that the ICC should keep its sole focus on genocide, war crimes, crimes against humanity.
But TI has
go ahead.
But TI has this definition, a more narrow definition of grand corruption, which implicates acts of corruption committed by public officials, which represent roughly around $10,000 in damage, which is fairly low, but which damage human rights. Right? They violate human rights, and therein we might find the nexus that we might need to connect that to the ICC.
Yes, and in 2015, I participated in a program where that statute was being discussed, and I explained why I thought, as a former prosecutor, it's a very poor idea. I mean, at that time, there had to be essentially you had to prove somebody took a bribe, took money in exchange for an official act, and that official act had substantial impact on human rights, significant human rights. If you're a prosecutor, it's hard enough to prove the conventional elements of bribery. And if you were a prosecutor, you wouldn't want to have to prove a violation or a serious injury to a group's human rights as well.
Factor.
Right, an extrinsic factor. Where that comes in as a practical matter, a prosecutor in the ICC, a prosecutor in the United States federal courts is going to set priorities. And so if there's somebody who's taken a bribe and also violates human rights, that would be a high priority case, but you don't have to prove the violation of human rights. In addition, the impact on victims is a legitimate sentencing factor. So you give a longer sentence to somebody who didn't just take a bribe, but it was a bribe that kept a hospital that was supposed to serve an impoverished area. You would punish that person more severely. But there is this effort, and Transparency International has been exploring it for a long time, to get a new statute that would be prosecutable in the ICC. And personally, I think that's not a good idea.
Okay, thank you. The OECD convention holds as one of its main tenets never to take into consideration economic factors. So these companies that might be considered too big to fail, we'll prosecute them anyway. We won't take that into consideration. Do you envisage the new anti-corruption, International Anticorruption Court to have similar mandates?
Well, let me say the following. That may be the policy of the OECD Convention Against Bribery, yes, but it rarely comes into practice because 40 countries, the last time I looked, signed the OECD Convention Against Bribery. Only 4 of them have ever had a prosecution, yes, and almost all of them are United States. Yes. So, these are interesting academic issues, yes, but we don't have to worry about 36 of these countries sinking their largest corporations.
Yes, this is true.
So that's one. And, I think I don't think the precise analogy that I discuss is too big to fail, but it is external consideration. So, for example, when Tony Blair was the Prime Minister of the UK about 10 years ago, the UK prosecutors were investigating whether Saudi princes demanded and received huge kickbacks from BAS, the British arms firm, to sell arms. And they were closing in on key members of the royal family, like Prince Bandar, who'd been the ambassador to the United States, among other things. And the King of Saudi Arabia called Tony Blair and said, you have to quash that investigation. Otherwise, we're not going to cooperate on terrorism. And Blair closed down the investigation because of external considerations. And then BAS was prosecuted in New York for FCPA violations, but only for not keeping their records.
Books and records provision.
Yes, not for paying bribes.
Proverbial slap on the wrist.
Right. Yep. So I think that if there was an international anti-corruption court, it would not be subject to the same kind of pressures that the UK was subject to in that case.
Okay. Would prosecutions before this new court be subject to existing standards? And I'm thinking of compliance standards, not obviously ISO 37001, but higher compliance standards, and for corporations at least. And if so, which standards? How would you judge a company's compliance culture?
I would, if they're paying a head of state or somebody close to the head of state, they don't have an effective compliance culture.
Somebody large enough to be tried here.
Right. If you're, this is not low level bribes to get a small contract. This is a very powerful person who's not going to sell an official act cheap. So I don't anticipate that's going to be much of a problem. So
strict liability, perhaps?
Well, no, it's criminal liability.
Broadly.
No, you have to, there virtually every country, 186 parties to the UNCAC, has a law that prohibits bribery. If you pay a bribe to a corrupt leader or a leader of a nation, he took the bribe, so he or she is corrupt. If you have sufficient admissible evidence to think you'll probably be able to prove that beyond a reasonable doubt, that company should be prosecuted, in my view.
Okay. The ICC, again, not to invite comparisons, but the ICC has historically frowned upon, neglected or turned its back on in absentia prosecution for many reasons, some humanitarian, some reasonable, some not so much. Do you think that a new international anti-corruption court would try the corrupt in absentia?
Well, they've charged people who aren't in custody, like Bashir in Sudan. I must confess, I haven't thought deeply about this. There is a question about whether it's a valuable use of resources to try somebody who's not there.
Well, there's the deterrence factor. It might be more of a social impact.
Well, there's also something else. I mean, if you try somebody who's refused to come before the court and convict that person, if they ever leave their country, or if there's a change of leadership in their country, they could be arrested and not put on trial. They could be in prison. But generally speaking, in the United States, we don't try people in absentia, and it doesn't immediately appeal to me.
Okay. We're almost done.
No rush.
Finally, a little bit more of a personal question. The U.S. legal tradition, jurisprudence, tends to favor constitutional supremacy. Essentially, nothing above the Constitution. Why would you stray so far away from your native legal tradition?
Actually, this isn't straying from American tradition. The International Anticorruption Court is based on the American experience. Okay. So in the United States, we don't try corrupt state and local officials in state courts.
Right.
We try them in federal courts. When I was the chief federal prosecutor in Massachusetts, the vast majority of our biggest cases were against people very close to the powerful mayor of the city of Boston. And I mentioned, I think earlier, that 8 years ago I sentenced the former speaker of our Massachusetts House of Representatives Parliament to prison. So the states often don't have adequate laws. Under the laws of Massachusetts, you can't get a wiretap in a public corruption investigation. The legislature won't permit that essential tool to be targeted on them. You can under U.S. law, right, but not under Massachusetts law. The state police don't have experience like the Internal Revenue Service or FBI in unraveling complex financial transactions. And most significantly, the state prosecutors, called district attorneys, are elected. They're part of the political establishment. Right. The federal prosecutors are appointed by the president. So we prosecute corrupt state and local officials in federal court. The International Anticorruption Court is built on that model. You have states, countries, could be Mexico, could be Turkey, could be Russia. They have their own state laws, but if they're unwilling or unable to enforce those anti-corruption laws, the laws that prohibit bribery and extortion and money laundering, against their own officials, those officials would be prosecuted in the International Anticorruption Court, which is analogous to the United States federal courts in my country.
And where do you envision them serving their imprisonment time?
That's a good question. It could be in their home country. I think it would more likely be in some neighboring country that's a member of the court.
Close by, but not at home.
Probably not at home if they were still very powerful in their own countries. And that's the reason they're being prosecuted in the International Anticorruption Court, because their own countries won't prosecute them. You want to make sure that they were properly, humanely, but not too comfortably in prison.
No, almost by definition, we're talking about politically exposed people who hold sway, to say the least. Okay, Judge, thank you very much. I hope I'm sure that the people who view this will get a lot or gain a lot from your experience, and I hope we will stay in touch and we will be able to help you with this project.
We look forward to it. Appreciate it.
Thank you. This was amazing. Awesome. So I hope you enjoyed this. I know we had a great time. We learned a lot from the judge and from his team, and we will keep you posted as to any new developments that we find concerning the International Anti-Corruption Court. And of course, whenever we have new guests, we will let you know ahead of time so that you can, prepare for our special episodes. So again, this has been The Wife of Caesar. My name is Michel Levien, or Michel Levien, either is fine. And I hope you have a happy Monday.